तो मैं ज्वाइन करता हूँ इस बार मैं ज्वाइन करके आऊँ मीटिंग में।
You can start the meeting.
ओके ओके, मैं वेट करता हूँ आपका। हाँ, एक बार हाँ एक बार मैच चेक कर लेंगे ज्वाइन करने के बाद, उसके बाद स्टार्ट करेंगे। ओके ओके ओके।
Good evening, friends. Brijmon sir, am I audible? Hello? Hello?
Audible, audible.
Okay.
Audible.
Brijmon sir, एक minute, just I'll talk to Brijmon sir and we'll start. Hello, Brijmon sir. Brijmon sir?
हाँ
हेलो ब्रिजमोहन सर, आपको आवाज आ रही है मेरी?
मगाशी येत होता त्यांचा आवाज.
हा, आता येत नाही. त्यांना जस्ट एकदा परत फोन करून विचारतो आणि मग आपण स्टार्ट करू. एकदा त्यांचा
मगाशी येत होता.
हो मगाशी येत होता. सागर मी आहे. तू जरी मला होस्ट करून निघाला हे
या
चालेल.
केलं. चल.
ओके ओके, थँक्यू. हा ओके. Dear friends, there is some technical error, so we'll wait for 5 minutes and we'll start. Meanwhile, those who are appearing for the first time, if they have any queries, they can talk to us. We'll try to resolve their queries. Everyone is getting what I'm saying?
Yes, sir.
Those
Yes,
who are
yes, sir.
those who are joining for the first time is those who are appearing for the first time examination. If they have any queries, they can ask us. Whatever possible, we'll try to solve their queries. Till the time our today's faculty joining us, till that time we can talk.
गुड इवनिंग जादू सर, मेरी आवाज आ रही है?
हाँ सर, आपके now you are audible. You are audible, sir.
Okay.
Just I'll introduce yourself. Good evening, friends. Very warm welcome to all of you for this wonderful lecture on third party insurance. Third party insurance is one of the important topics from examination point of view. Maybe 6 to 7 questions have been asked in the past on this particular topic. Today, I have a great pleasure in introducing our today's faculty, Shri Brijmohan sir. Brijmohan sir is a very special person to us. He's an ex-serviceman. He has served Indian Navy for 15 years, and in 2017 he has joined New India. He's a very brilliant student. He has cleared his fellowship exam in his first year only, and most importantly, he's working with third party department, Mumbai TP Hub Thane. So he has the practical knowledge as well as theoretical knowledge. And one more thing I would like to add to it: last year he appeared for this promotional exam, and he has first-hand information or first-hand experience of third party, how the questions have been asked are asked in the examination. So he is the best person who can solve all your queries on third party insurance. One request to all the students: please don't ask anything outside your examination box, because what we are practicing in our day-to-day office, or there may be some queries regarding your clients or something that. So please don't ask those queries in this particular session, because this is being examination oriented session, so we will try to focus on examination point of view only. So Brijmohan sir, over to you. You can take this lecture, and I am there with you in case of any problem. I am there till the end. Brijmohan sir,
Thank
over to
you.
you, sir.
आवाज आ रही है सर?
सर आ रही है आवाज, सर आ रही है आपकी आवाज.
हेलो.
Yes sir, you are audible.
Thank you very much, Jadal sir, and thank you all the team with organizing such type of lecture for the participants. Thank you, BVKS. And we'll start with the lecture. Good evening to all the participants. Today lecture is on the motor third party claim. As sir told, 5 to 7 questions may arise from the asked from the motor third party. Just a minute. My screen is visible to all now. My screen is visible.
Yes, sir.
Yes, sir.
So today I am going to
Yes, sir.
today I am going to cover all these points. First, we will have the brief introduction, which is not necessary for the exam point of view. Then we will provided for the type of third party compensation to be paid. What is there in a calculation of national versus Parnay Shetty? This is the landmark judgment. Then we move on the important section of Motor Vehicle Act, that is Amended Act 2019, as well the 1988. Then we'll see the driving license, some definitions, and the other important section of IPC as well the Motor Vehicle Act. We see the Consumer Forum Protection Act, which has been amended in 2019. We'll see the ombudsman and some government notifications later on. So first, this is the brief history.
Your voice is very low.
सर माइक थोड़ा नजदीक लीजिए.
Right. Now it is audible.
Perfect.
In history, you see, in India, Motor Vehicle Act was first enacted in 1939, and by that act only, from 1st July 1939, the third party insurance made compulsory. Then later, so many recommendations and amendment has been carried out, and latest amendment is the 2019 amendment of Motor Vehicle Act, which is in force from the 1st July 2020. Because of the COVID period, it has implemented later on. It was notified in 2019.
The
that is
voice
9
is
August.
very low, sir.
Sir,
Now
we
I am
are
audible. Now I am audible now.
Voice is not clear, sir. You are audible, but clarity it is lagging.
I was talking about Jadhav sir. Is it okay that voice is clear or it is still having issue, audio issue? Anil Jadhav sir, any participant?
Voice is
Am I
clear.
audible clearly?
Still it is same, sir.
Voice is not clear, sir.
It's echoing, sir.
Anil Jadhav sir, am I audible now, or is it still same?
Yes, sir.
Yes, sir. It
Now
is audible now, sir.
Yeah, sir.
Audible, sir.
आवाज सही.
It is clear.
Now it is okay, sir.
Okay. I was talking about the brief history question. I have not seen from the history, so we can skip. We are talking about the latest amendment which was carried in 2019. It is in force from 1st July, 1st April 2022. Because of the COVID period, implementation is later on. Government has notified in 22. That is the various provision of this act was implemented in 2022. See the types of motor third party claim. These are the types. Claims application is filed under motor accident claim tribunals. Then there is a hit and run cases and the claim compensation under Employee Compensation Act. So four kinds of claim compensation is been filed earlier. Now the section 140 has been replaced. Entire chapter has been omitted. We'll see in the Amendment Act what the provision has been came from there. So first application is coming under section 166, where unlimited liability is there. We'll see what are the compensation is being paid in the various types of application which is being filed before the motor claim accident tribunal and before the employee compensation labor court, or it may be the industrial court. So section 140, as I told, it has been omitted as per the Motor Vehicle Amendment Act 2019. It was the interim compensation and it cannot be recovered if it has been paid. So what are the amount? Question, this entire chapter has been omitted, but question may arises from this. It is popularly known as the no fault liability. So compensation was of 50,000 and 25,000 for injury case. If it is a death, it's a 50,000, and if it is an injury, it's a 25,000. Next two slides is more important, where I have written so many compensation amount. This is being asked in the exam. So another compensation comes under hit and run, where the identification of vehicle is not established by investigating by the police authority. This uh, establishment of the vehicle where it is not being established, then the hit and run, it is known as the hit and run case, and compensation for that is rupees 2 lakh for fatal case and rupees 50,000 for grievous hurt. If it is a minor injury, no provision is there. Then the section 164 is there. 164, earlier it was known as the 163 alpha. Here also only two provision is there. One is for rupees 5 lakh for fatal case and rupees 2 lakh 50,000 for grievous injury. Moving to the next slide. TPPD. TPPT liability is there. That is a rupees 7 lakh 50,000 and for other vehicles, and rupees 1 lakh for motorcycle. Maximum cover it is. Only thing is there, we need to make sure it should not be restricted for a statutory TPPD liability for 6,000 rupees. If insured has availed the premium discount for restricting his TPPD liability for rupees 6,000 only, then it is only the 6,000 rupees, not more than that. Then we see the Employee Compensation Act 1923. Yeah, Employee Compensation Act 1923. I was confused because now we are in 2023. So I thought it was wrongly written over there. Latest amendment, it has came in 2017, and that is in effect from 15 May 2017. What are the compensation and what is the main this thing condition? I have written and highlighted it. It should be the personal injury which is caused to an employee by accident, and it should be arising out of and in the course of employment. Both the provision is there. It should be arising out of as well. It should be the during of the course of employment. Both the conditions should be fulfilled. Then only this Employee Compensation Act is being paid and it is attracting. So what is the liability? Fatal case, it's a 50% of the monthly wages. Now the monthly wages is also has been revised from 2020. I have written over here that is 15,000 with effect from 3rd January 2020. Earlier it was 8,000. So for fatal case, 50% of the monthly wages and relevant age factor that is mentioned in the EC schedule, Employee Compensation Act schedule is there. But minimum we need to remember that in the fatal case, minimum compensation under EC Act is 1,20,000, and for permanent total disablement it is 1,40,000. And what is the compensation? It is a 60% of the monthly wages, then the relevant age factor, and if it is a permanent disablement case, there is a disability, and it is the functional disability, not the physical disability. Here the disability is known as the functional disability. So multiplied by the disability percentage. So this is the compensation being paid in the Employee Compensation Act. What are the multiplier for 16 years from the 16 years of the age of an employee? It is the highest, that is 228.54, and it is reducing gradually as the age of the employee is increasing, and it is for the 65 for the age of the 65 years it is 99.37. So in between so many data is there that we need not to remember. This is the minimum and the maximum. We should remember what is the minimum and the maximum. Monthly wages, I have told you, it has been revised now the 15,000. So now
Sir,
the
are
main
these
claim.
the minimum wages or the maximum wages?
See, it is popularly known as the minimum wages, but as per this thing, it's a ceiling.
Sir, 1 minute previous slide, sir.
Employee Compensation Act, it's a ceiling compensation. There it has been mentioned. Just mute, sir. Anyone unmuted? Everyone is claiming it's a minimum wages. Minimum wages is being notified by the respective state government. It's a maximum compensation, monthly wages we can say, but nowadays driver and the other employee which is employed by the this thing, it's a 15,000, more than 15,000 also it is increasing. Normally we are issuing the WC policy as per this act, not arising out of the motor only. It's a WC policy we are issuing on the monthly wages at the rate of the 15,000 rupees. So it is not the minimum. Clear, ma'am? Excuse me. Someone has
Yes, sir.
asked about the
Yes,
monthly
yes,
wages.
sir. Clear. Actually, I was unmuting my mic. Yes, sir.
Okay, okay. Moving to the next slide. Under claim compensation under section 166, nowadays maximum claim application, that the 90% of the claim application is being filed under section 166. Most important section is there, and liability of the insurance company and compensation whatever is being paid is the unlimited compensation is being paid in this section. It's depend upon the basically what is the age, income, and how much dependent of that family member who has died in the accident or who has injured in the accident. It's depend upon all the three factors. Then what is the formula? I have shortcut over here the formula. Monthly income, it should be multiplied by 12 for making it the yearly income. Then the dependency. Dependency is the only thing. Personal expenses. We have to deduct the personal expenses from the total income. If someone has died in an accident, the expenses which is on his own is not continuing. So that personal expenses we are deducting from the total. So that is known as the dependency. Then the future prospects, FP.
Sir, please
This is the
explain
FP.
again. Sir, please explain again what is dependency.
Dependency is the dependency of an individual towards his family. How much families depend on his monthly income or the income whatever he is getting, how much his family member is depend on that. If the family member is suppose 3-member family is there, then
Or sir,
it
we
is
can, sir, we can say it that way. What part of the income is the person that he died, he used to spend on himself? Like if he was a bachelor,
that is
he
a
used to
personal
spend.
expense. Huh, huh.
Yes, that
That is a
that's a
personal
personal expenses.
expenses. And if we
Yes.
deduct the personal expenses from whole, it will become the dependency. So
Dependency.
for the bachelor, it is decided. Excuse me, sir. Mute yourself. Whoever is there unmuted. Uh, so if we deduct the personal expenses from the whole, it will become the dependency. For bachelor, it is decided by the apex code that the half of the his income is being utilized and being expenses on his own. So half only, uh, dependency is here, half only, half of the income. So like that, if the dependent is 2 to 3, if member is 2 to 3, suppose mother, father and widow is there in the case of fatal case. So personal expenses is 1/3. We have to deduct 1/3 from the whole, so it will become 2/3 dependency. Where the claimant is 4 to 6, so personal expenses is 1/4. Personal expenses is 1/4. So what will be the dependency? Anyone? Can you please?
3/4.
3/4. 3/4. Obviously. So if a
So, so what was the lowest multiplier in this consumer workman compensation? 99 point?
99.23, ma'am. I have said 99.37. I have mentioned over here. You can, sir is going to share this PPT, so you can refer it. Minimum is 99.37 and maximum is 228.54. So I was talking about the dependency. So if a family or dependent comprising more than 6 dependent, mother, father, then the more than 2, 3 childs and the widow is there. In that case, that the minimum personal expenses which is being deducted, that is the 1/5. So in the case of dependency where the more than 6 claimant is there, what is the dependency? What is the dependency? Anyone?
1/5.
What, sir?
4 by 5.
4 by 5.
4/5. 4/5 will be the dependency in the case of where the claimant is more than 6. So multiplier, this multiplier is important. It's a simple multiplier in is being used as per the pernicity judgment. 5 to 18, it is also depend upon the age, and it is a very simple to remember. Up to the age of 50 years, up to the I will show you the slide. This is the slide for the multiplier. You have seen here clearly I have mentioned up to the age of 50 years, it is reducing by 111. First, you remember up to the age of, I have not corrected this slide till date. For the 15 to 25, it is a multiplier of 18. Wrongly, it is entered as 25. It is a 18 from 15 to 25. Then it is reducing by 111 up to the age of 50. If you don't remember, if you forgot what is the multiplier for the age of 36 to 40, use just after 25, 26 to 30, 17, then 31 to 35, 16, then 36 to 40, 15. So you can recalculate in exam and answer. After the age of 50, it is reducing by 2. For 51 to 55, 11, then 9, then 7, then 5. And for this age, for the fatal case, if the age of the person is more than 70 years, that is not comes under the purview of pernicity judgment. So no multiplier for the age which is who is having the more than 70 years. So this is all about the multiplier. Then the general damage, that is a non-pecuniary damage. It is a loss of estate, 15,000. Funeral expenses, 15,000. Loss of consortium, 40,000. And it is increasing by 10% on every 3 years. This pernicity judgment has came in 17, and it is being increased by 10% on every 3 years. So now it is you can total, if it is a fatal case, it is a 70,000 plus 7,000, 77,000. Then the future prospects, pernicety judgment has came with the this it has pernicety judgment has simplified this future prospects, and it is applicable for all the kind of the employment, whether it is a permanent employment or it is a self-employed or fixed salary. So if a person having a age below than 40 years, the future prospects applicable for the permanent job, it's a 50%. For self-employed, it is a 40%. Then if that age is between 40 to 50, it's a 30% and the 25%. And if it is a 50 to 60, then it's a 15% and 10%. That is being added. What is the future prospect? Future prospect is the future earning power of an individual. We are getting promotion in coming days, or this promotion exercise is also being scheduled for the promoting of employee. So it's a future earning power. The employee is getting the salary, or he may earn the more in future. That's why it is being added on the current income of an victim. Is it clear?
Sir, if the age is 40 means we have to take 50 or 30, sir.
If the age of 41, then we have to calculate the 40 to 50. If he is a permanent job, then the 30%. And if
No,
it is a
sir, if
self,
the age is 40, 40 means either second slab or first slab, sir. 50 or 30. 40 means age. Which slab?
Up to 40.
see,
we will take.
normally last completed age is being calculated up to the age of 40. Below the age of 40 na, it has clearly written that the 50%. If it is a 40 days and 1 month na, or 1 day na, it will come to the 30%. Question will not come directly like that.
Or if it's
One thing,
40,
sir. One question, sir. Regarding loss of consortium, whether we have to apply for
Loss
each
of consortium, tell me.
member, whether we have to apply for each member or it is maximum.
No, in pernicety, it is clearly pernicety case is also of the widow case, and there it has mentioned it's applicable only to the husband and wife. If someone lost his wife and someone lost his husband, that the loss of consortium is being applied. But later on, one more judgment has came from the apex court that is applicable. That has magma. It is popularly known as the magma. So magma is telling that the each claimant, all the claimant will entitle for the loss of consortium. That is known as the parental consortium if some child is lost his father in a fatal injury, and it's a filial consortium if uh, someone lost his child. So now, as per magma, loss of consortium is applicable for each claimant, and earlier, as per pernicety, only loss of consortium is applicable to the husband and wife.
Okay, sir.
Clear, sir?
Clear,
Sir, what about people, those who are working in private job? For future
Private job may be of two kinds. Someone working in TCS or someone working in the Asian Paints, what I have seen in the our claim petition. So if he is not on the fixed salary, clear, the mentioned word is the fixed salary. One, the security person in our society is getting a fixed salary. All the contractual job in the government sector also nowadays on the fixed salary, not for the private job and the government job. If someone is on contract and getting a fixed salary, I have mentioned the fixed salary, that the pernicety very much clearly saying if someone is self-employed or on the fixed salary, he will get the future prospects as per this table. And if someone is having a permanent job, he will get on this table will attract for this future prospects. So it is not the government job or private job, it's a fixed salary or it's a permanent job. Contractual job for the time being 2 years, 5 years, 10 years. Is
Sir,
it clear?
what about contract workers? What about contract workers?
Contract workers, he's not on permanent job. So second table will attract.
Sir, does it mean that all the persons who do not have a permanent job, I mean, the second table will be applied to all those persons? Is it so?
Your question? Sorry.
All those persons who do not have a permanent job, they fall in this second table of self-employed oblique this fixed salary table.
Right, sir. That is very much clearly mentioned in the Parnashati. Only permanent job person is having this, will get this future prospect at the rate of 50%, 30%, and 15%.
So what is there any example of permanent job, sir?
We are on the permanent job. Termination, if we are not committed anything, permanent job, all the person who is in uniform and the earlier government sector is having the permanent job when they are not appointing on the contract, because outsourcing is everywhere nowadays. If you see railway, teaching, everywhere outsourcing is there, and people is being applied in the being appointed on the basis of the contract.
Sir, in TCS, Asian Paints, Berger Paints, they are also in permanent job also.
See, you have to see the appointment letter. Appointment letter clearly mentioning whether it is for the time being 2 years, 3 years, or he is on the payroll. He's on the payroll. He will get all the, see. If you see the earning portion and the expenses portion of the salary, now earning portion and expenses portion. If he's not on the fixed salary, he is getting the other allowances also. That means he is permanent, having the permanent job. Normally, government job, if not on the contract, is being treated as permanent job. Sir, please mute yourself. Sir, please mute yourself. Or should I move ahead from the future prospects? Is it clear to all?
Yes.
Yes, sir. Yes, sir.
Sir, loss of estate. Can you explain what is
Yes,
this
sir.
estate?
Yes, sir.
Loss of estate. See, one who has lost his life or who is there in the fatal case, he is the estate for the entire family. एक संपत्ति है वो, मतलब एक धरोहर है उसकी. So that is a non-pecuniary damage. It is being used as a it's a nominal amount which is being paid for the loss of estate. That's it only, nothing else. We have a estate, so many estate, kind of estate. So mother, fathers, parents, children, everyone is known as the estate. So loss of estate is applicable to all.
Okay, sir.
सर ये जो 10% इंक्रीज इन एवरी 3 ईयर है, इस बार सेकंड टाइम इंक्रीज हो गया, तो हमें 70,000
नहीं, अभी हाँ इस बार हो गया सर. जुलाई अक्टूबर का था, तो अभी
नवंबर में हो गया.
हाँ नवंबर में हो गया.
77,000 का 10% लेना है.
नहीं सर, 70 पे ही, बेसिक पे 10% इंक्रीज होगा सर.
Sir, this is for fatal cases only, no sir. In case of disability, sir, 75% disability, 80% like that means.
Pernichety only applicable for the this thing, fatal case only.
Fatal case. Okay, sir.
Excuse me, sir.
Tell me.
When you are calculating the personal expenses in the sum, if we multiply it like 1 by 3 means 1 by 3 or 2 by 3, we have to multiply it.
You have to multiply. I have written in formula, it's a dependency, and dependency I have written lower, just below that. It's a whole minus the personal expenses. So you have to deduct it. If it is a 1/3, personal expenses 1/3, you have to deduct, and 2/3 will apply over there. 2/3, 3/4, 4/5, like that you have to apply.
Sir, this year this 10% is applicable. That means loss of consortium that add 40,000. That means that becomes 44,000 now. Is it so?
Now it is a 40. Now it's a 48,000. Sir, as earlier, someone has asked. So now the revision is second time. So what will be the loss of consortium? All the general damage. All the general damage will be increased by the 20.
Okay, sir. Thank you.
Question is not more specific on this, sir.
Okay, sir.
Should I move ahead, sir? This was the
Please,
multiplier
sir.
chart I have explained earlier also. Now this is two question is there. See, these two question is there. I have mentioned over there. Just a minute.
This PPT you are going to share, you share no, sir.
Can anyone read from your end this first question? Can anyone read from your end the first question?
A married person died in motor accident on 1/1/2023 and left with 4 dependents, including widows. He was having permanent job and earning rupees 20,000 per month, and his date of birth is 1/6/1983, as per documentary evidence. Police authority has charge sheeted 1/4 driver for causing death.
IV driver. It's an insured vehicle driver.
Okay, okay. For causing death under section 304A, calculate compensation payable to legal hands.
So see here I have mentioned you have to deduct the date of birth from the date of accident, that you come to know what is the actual date, what is the present age at the time of accident, the age of the victim. Then the earning I have mentioned. I have also mentioned the dependent. The 4 dependent is there. And this the 304 alpha I have mentioned, the 304 alpha, that is a section of IPC. It will attract at the in the case where the fatal injury is there. So you can calculate this compensation amount considering the I have considering the 10% increase in the general damage. Now it's a 20% increase in the general damage. Now you can calculate as the consider it's a 10% only. So see, I have also given the calculation over here. I will briefly explain for quickly. Just a minute. See, income of the person is 20,000. Then the age present, age of the victim at the time of accident is 39 years 7 months. But we should take the last completed age, that is the 39 years. For 39 years, if you go by reducing 111 up to 25 18, then 26 to 30 17, 31 to 35 it's a 16, and the 36 to 40 it's a 15. So this will attract, the multiplier is the 15. Number of dependent 4. So what is the personal expenses? It's a 1/3. Then the dependency will what? Dependency is 1 minus the personal expenses. That the 1/3 is the personal expenses. So 3/4 will be the dependency. Here I have mentioned he is on the permanent job, not on the fixed salary. So
It
for
should
the
be one
permanent
by
job,
4, not 1/3.
So, sir, it
sorry,
should be
sorry,
1/4.
I
Dependency 1 by
mentioned 1/4 is there. I have written over that it's a wrongly posted. It's a I have deducted correctly, but here 1/3 is only 1/4 is there. 4 to 6 it's a 1/4. More than 6 it's a 1/5. So 2 to 4 it's a 1/3. It's a 1/4. So 3/4 will apply. Then the future prospects is the 50%. You see, 20,000 3/4. Then the monthly income will be converted into annual income 12. Then the 50% is the future prospects and the multiplier. This is the compensation. 40,50,000 is the compensation. That is a pecuniary damage. It's the actual loss. Then the non-pecuniary damage, there is a widow also. Loss of consortium will attract. Then it's a 77,000. So total compensation amount will come 41,27,000 plus medical bill, if any, before the accident. If he has admitted in the hospital, some expenses there that will be added, and then the interest will attract on the all this.
Sir, can you show that?
Interest will not attract. Tell me, sir.
Sir, can you show that this multiplier slide again?
See this one. First one is the wrongly written. It's a 18. Then the 36 to 40 it's a 15.
Okay,
Should I
sir.
move it,
Okay,
sir?
thank you. Yeah, please.
Yeah. Then the another question I have mentioned over there: a 65 years old driver died in motor accident on first 2023 and left with 4 dependents. He was earning rupees 16,000 per month. Legal has filed application for compensation under WC4. He's a driver. Earlier, he cannot claim under motor MACT for a motor accident claim tribunals. He was employed by the owner of the vehicle. So
Sir,
he is.
calculation of previous question.
I will
didn't
show you.
understand.
I will show you. Then the question asked to calculate the compensation payable to the legal heirs. See, this is the earlier solution. Tell me if anything. Should I again explain the solution of question number 1?
No, sir, yet 20,000 into 3/4. That I didn't get.
See, this is the 3/4 is the dependency in this case.
Sir, 20,000 into 3, 3.
3/4 is the dependency. So what is the monthly? What is the
How
monthly?
40 lakhs, 50,000 is coming? We are not getting.
Sir, 1,80,000 तक आता है. 20,000 into 3/4 into 12, it comes 1,80,000.
1,80,000.
हाँ.
Then you multiply by 15.
So
Multiply by
15.
this multiply
Or
at
add.
15, 15, it is coming actually 16, right?
No, ma'am. For 39 years old, it's a 15.
It's a fatal case, then 50%. And it's not a case of disability.
सर 40,50,000 कैसे आया नहीं समझ में आ रहा
Question
है.
he. See, just a minute.
Sir, there is a sign of plus instead of multiply.
No. Sign of plus is correctly written, sir. It's a 50% future prospect that you have to add. 50% is the future prospects that you need to add. See, 20,000 is the monthly income. So 3/4 is the dependency here. So what will be the total actual dependency monthly? It's a 15,000 rupees. Clear? Is it clear? 15,000 is the dependency per month.
Yes.
Okay. This 15,000 rupees will be multiplied by 12. So it will become the annual income, annual dependency. Okay. So annual dependency will be multiplied by 15.
Sir, into.
So it's a 27. No. Hello.
Sir,
Tell me,
into
sir.
12. 20,000 into 3/4 into 12, it comes 1,80,000.
Then you multiply by the 15. That is a multiplier. It's a 27 lakh.
Into 15. Into 27 lakhs. Right.
27 lakh. Then you increase it by the 50%. That is a 150% you can directly put over here. So if we made it a 150%, it's a 40,50,000. 27,000 is the 100%. You have to give the future earning power also. That is a future prospects. That is a 50% of this this 27,000, 27 lakh. So what is the 50%? It's a 13 lakh 50,000 rupees you need to increase that as a future prospects. So this 27 lakh and the 13 lakh 50,000 that become the 40 lakh 50,000. Is it clear now?
Yes, sir. Yes, sir.
Yes, sir.
Then you add the non-pecuniary damage, that is the 77,000. So completely it will become the 41 lakh 27,000 plus medical bill if any, and then the interest.
Sir, can you show me the future prospect by the file? Page.
This is the future prospect. As he is having the age of 39 years at the time of accident below, and he is on the permanent job as the question is I have mentioned in the question. So this factor will applicable, that the 50% will applicable future prospects.
Got it, sir.
You have to remember 50%, 30%, 15%, then the 40%, 25%, and 10%. For the person who is having the age of above the 50 years and the below 60 years, that the minimum 10% is applicable future prospect. And nowadays, for
Sir,
self-employed, if someone is, tell me, sir.
hello. Sir, this general damage total comes to 70,000. That 70,000 needs to be added in each and every judgment according to this Pranay Sethi case. That means whatever the compensation will be there, the general damage remains same for 70,000 for all, or just because there is a video, that is why this
As per,
40.
as per, as per, there is a video now. That's why 70,000, 77,000 added over here. Pranay Sethi is the case of a widow only. The
Okay,
widow
okay.
has filed the claim application. So here, loss of consortium, he has, and earlier Sarla Verma also the case of widow. So both the cases only telling about the consortium which is applicable to the husband and wife. But later on, Apex Court also given a judgment for the Magma versus, I think, it's a national insurance. There it is. I will confirm Magma is against which insurance company, where it is telling each claimant is entitled to get the loss of consortium. As per Parnasity, loss of consortium is not applicable for the bachelor. We are
Okay.
earlier not considered, but is a bachelor for parents. It's a filial consortium known as the loss of the children is known as the filial consortium, and Magma is supporting that. So nowadays, each claimant is entitled to get a loss of consortium as per this latest judgment. Parental consortium, filial consortium, and loss of consortium, which is applicable earlier also for the spouse, husband and wife.
Okay, sir.
So we'll move to the next question. It is
Sir,
for
how
the 65
77,000 is
years
come?
old.
In 70,000, you have added 10%. Hello?
Because accident occurred on the 1st Jan 23. As the accident occurred on 1st Jan 23, the next slab has not then revised. Now in December, if I am talking in December, it has been again 10% more added the basic 70,000. So
So
if it is a
10% of
case where the
77 or
accident
70?
occurred in January 23, sir,
Increase of 10% is 77 or 70?
70,000, sir. 70,000, sir. Not on
Every
77.
time? Every time? On every 3 years?
Sir, other mute yourself, sir. Tell me, sir. Every 3 years, it will
There is
increase by
10% increase,
10%.
which is on
Okay,
70.
so 10% increase, 10% increase on the basic that is mentioned in the judgment. That is judgment of the 2017. It has mentioned that it will increase by 10% on every 3 years. So that will increase from 70,000 every 3 years, not on the further 77,000. No compounding is over there.
Okay, sir.
So that means if the accident is on 1st January 23, then we have to add 14,000 or 7,000 only. Because
No,
already
only 7,000 because 17 in 17 this judgment has came in the month of October. So in October 20 it has increased by 10%. So in October 23 it will again increase by 10%. If accident occurred before October 23, it will only increase by 10%. If accident occurred in December or November, it will increase by 20%.
Okay, sir. Thank you.
Clear, ma'am?
Yes, sir.
Moving to the next question. 16,000 is the income of a driver. As I have told, he may earning nowadays, transport driver may earn the 25,000, 30,000, whatever it is. But documentary evidence should be there. Question is there 60,000 is earning by a driver and accident occurred again in the January 23. So why I have written over there the 65 years, because it's some highest age where the uh, multiplier WC schedule multiplier is there. That's why making the question simple, I have made this question. So he is also having the 4 dependent. So what is the fate of the dependency in the WC cases? claim compensation under WC forum? Anyone? Can you tell me any dependency and personal expenses is being deducted for calculating the claim compensation under WC forum?
No.
No, sir. No, sir. No.
Rightly.
Only a factor.
Because only factor is no dependency, no personal expenses is being deducted or is being calculated for claim compensation under WC forum. So you have to, if it is a fertile case, you directly reduce it by the 50%. If it is a injury case, you have to directly reduce it by the 40%. You need to take the 60%. So see, he was died in the accident. So 16,000 will be uh, multiplied by the 50%. Then the maximum minimum factor, that is the age for the 65 years old, that is the 99.36. So it will multiply by the 99 by the 36. The total claim compensation comes as a 7,94,880 plus medical
So
bill,
there is
if
one.
any, that will be. Tell
So
me,
there is
sir.
one point. As you
Yeah,
have told that the magma case, as per consortium, will be payable to the all dependents.
all the claimants, whatever the claimant
Claimants.
is there, 4,
Yes,
5,
sir.
6, yeah.
But if, yes,
That is
in
at the
that
rate of
case, there is
40,000.
that is in the case of that is 4 dependents. And usually in
4
the
dependent.
applications, all the applicants are made in the applications under section 166. Then we have
Calculate
to
claim
add the,
compensation.
my point is on regarding consortium point only. Whether we have consortium to be added for the all 4 persons or to individual only. In getting the
As per
compensation.
as per
per
Parne
Parna, it is
Shetty, I
clear,
have,
sir. But you have told that there is one point after magma.
yeah.
What will be the situation right now after magma decisions?
Question will come specific. Calculate the claim compensation as per Parne Shetty, or calculate the claim compensation as on today. If it is
Okay,
as
if
on
it
today,
came as on today on the date, when was the
sir,
magma decertification?
magma has came, sir, but till date tribunal is also not considering the magma in full force.
Okay.
If argument is not made by the claimant side strongly, then magma is not being considered by tribunal. So we need not to. Mumbai High Court is nowadays. I have seen the judgment from the Mumbai High Court, but at Thane we are not seeing the judgment coming as per the magma. Still,
Okay.
for the settlement purpose, we are not considering magma. So, if the claimant is resisting for that, that time we need to consider the magma,
That is
because
the
it
discussion of
is
the
there in the
MACT. Court.
yeah MACT, or the person who is the authority for settling the case.
Naturally, sir. Thank you.
So this another question I have given the solution. For the WC forum, there is a simple, you have to apply only for the 50% if it is a fatal case. For injury, it is a 60%. Why it is the 60% and 50%? Because as the case of fatal, personal expenses is discontinued. And if it is a injured person, that the personal expenses is still in continuing. So this 60% is coming, and then the age multiplier is being applied. Clear? Should I move ahead?
Sir, for WC
Sir.
funeral expenses, how to add? Sir,
For WC?
funeral expenses?
Yeah, funeral expenses, rightly questioned by the ma'am. I have not mentioned. As per WC Act, the funeral expense, what is the funeral expenses, ma'am? As per WC
5,000.
Act?
5,000.
5,000.
Yes, thank you, ma'am. It's a 5,000 rupees funeral expenses that need to be added for WC compensation. And what for the claim compensation under motor accident claim tribunal? What is the
15,000.
funeral expenses? 15,000.
15,000.
Right.
Sir.
Moving forward. Yeah, tell me, sir.
Wonder. Suppose is this not a case? I mean, this is not a case of fatal and a disability will be there. Then the 50% will be. I mean, 60% will be considered on place of 50%.
Yeah, for WC forum, if it is an injury case, then the 60% will be applicable.
And the remaining factor will be as it is, multiplier.
remaining age multiplier will be applicable.
That
No
okay.
no funeral expense.
Okay.
Sir, wages 50%, sir. Wages. Whether we have to take 50%?
Then disability percentage needs to be added, no?
Yeah, disability percentage need to be added, and that should be the functional disability. Disability should be the functional, not the physical only. Orthopedics, the MS is giving the disability percent of uh, uh, with an accident that the it's amputation case. 60% disability is there, but driver may not be may not. It is clearly he cannot drive a vehicle if one amputation is there. So functional disability is 100% of in this case. So they will argue for the 100% loss of the functional disability. In that case, license of the driver need to be cancelled because he is no more using the driver. Then we consider the 100% of the functional disability. Clear, sir? It should be the functional disability, not the physical disability only.
Sir, are we going to that kind of sum in next slide?
Next slide.
Are we going to see the same kind of examples in next upcoming slide?
No, sir. I have covered the other sections and the important aspects of the exam, so I am not covering. Just for the sake of this. For injury case, sir, one judgment is there, Rajkumar versus. I am not remembering. There it is clearly mentioned. Functional disability should be considered. Functional disability.
I just want to know that suppose the same case is not of fatal but of the disability, it is a functional disability. Then
Right.
what kind of the formula will be applicable and how much amount will be payable as a award? That I want to know, sir. That is why I have.
If more than 70%, 80% disability is there, sir, it will be treated as a 100% disability. But for audit point and other aspects, we will take the 70-80% only. Court is awarding 100%. Court has he has a consideration having the power. He can award 100% of the functional disability.
Okay, sir.
Student points. Moving to the further. Motor Vehicle Amendment Act 2019, which is in force from the 1st April 2022. It was notified on 9 August 2019. These are the amendment of this 50, 51. These are the amendment section of the Motor Vehicle Amendment Act 2019, and it is related to the relevant section, the section which was earlier in the Motor Vehicle Act 1988. That is, in the definition, in the explanation, we will get the section number that is as per Motor Vehicle Act 1988. So Amendment Act 50, what it is telling, Chapter 10 is completely omitted, and it is ranging from section 140 to 144, where the liability, no fault liability is there, liability without fault in certain cases. The complete chapter has been omitted now. Then come to the chapter 11, that is the insurance of the motor vehicle against third party. Here the definition of third party is there. Section 145(1) is telling definition of third party. It includes government, the driver also. It's a newly amendment that the driver is also considered as a third party. Any other co-worker on a transport vehicle. Cleaner may be there, conductor may be there, loading and unloading person is there, labor is there. So all are comes under the purview of third party. So this driver also now claim under Motor Accident Claim Tribunal. Is it clear? Earlier driver was not there as per Motor Vehicle Act. Driver was not a third party, but amendment is telling driver is also third party, so he can claim under Motor Accident Claim Tribunal. Section 146 is talking about necessity of insurance against third party risks. Also, public liability policy is mandatory for vehicle carrying hazardous goods. public tanker or maybe the other vehicle which is carrying the hazardous kinds of goods, petroleum products. So if it is a hazardous goods as per the Motor Vehicle Act, so it should have the public liability policy because liability is there on the major aspect. Then the section 147, we are issuing the policy of insurance as under this section 147. These all are section what I have mentioned is important, but where I will emphasize on the hello. Is there any question? If it is
As per section 146,
yeah,
the vehicle should carry both the policies or what? Public
both the
liability also.
yeah, for carrying hazardous goods, it should have a public liability as well as the motor policy.
Vehicle or manufacturing factory? Who should have public liability act?
Sorry, sir, didn't understand your question. Either mute yourself, sir.
Only public liability policy is taken by the manufacturer who manufactures hazardous goods. Is
No,
it
no,
not?
no, 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 sir. No, sir. Public liability policy should be carried by the at the time of carrying the hazardous goods. Manufacturing is there. He must have the public liability policy. But for the transit period from carrying the hazardous goods, they don't have the notional extension throughout the country, the industry which is making the hazardous goods. So if a owner is allowed his vehicle to carry the hazardous goods by his employee, that is the driver or the other person, then he should obtain the public liability policy if any mishap happened during the transit of the policy, and if liability comes in a larger way, then that liability only policy, public liability policy will cover the risk of public. Clear, sir?
Yes, sir.
We are issuing policy under section 147, and it is policy is being issued by a person who is an authorized insurer. Then the section 149, newly inserted section, important section is there. Here, settlement by insurance company and procedure thereon. These are the new, this 149 section is the new section. Because of that, we have a earlier we have a defense under section 149 too. So that now move ahead under section 152. Now it is known as the defense of the insurance company is mentioned in the section 152 because of the insertion of this new section under section 149. So insurance company on receiving the information about the accident shall designate an officer to settle the TP claim, and within 30 days that the designated officer may make an offer of settlement before the claim tribunal. If the offer is accepted by the claimant, then the tribunal will record the consent of settlement and payment shall be made within 30 days by the insurance company. That is the act only clearly telling. This question is also being asked, within how many days the insurance company is authorized to satisfy the award of the claim tribunal. That is the 30 days. So within 30 days, here also it is telling that the if settlement is there, you need to satisfy the settlement, you need to satisfy the award, that is the payment need to be made within 30 days. So remember the 30 days words. If the claimant rejects such an offer, then the date of hearing shall be fixed by the tribunal for further proceeding on merit. Is there anything in section newly inserted section 149? In this kind of litigation, there is no involvement of the advocate. That the information about the accident directly filed by the investigation officer, that is the police authority, to the claim tribunal, and claim tribunal on receiving the giving information to the concerned insurance company. Once the insurance company receive the information about the accident, they will designate an officer to handle that case, and that the designated officer within 30 days, by doing the investigation, by seeing the policy terms and condition and all the papers, he will, if it is all in order, he will make an offer for settlement, and further I have discussed. Anything in this? Moving forward. Moving forward, section 152, 150, subsection 2. Earlier it was known as 149(2). Here, duty of insurer is mentioned to satisfy award, and award second person insured in respect of third party. This is the duty of insurer. If the award has came, you need to satisfy the award, in which cases we are not liable to pay the claim compensation. No sum shall be payable by an insurer if there has been a breach of a specified condition of policy. What are the breach? What are the conditions? If the vehicle is being used for hire and reward, if vehicle is a private vehicle and it is being used as a commercial, it's a hire and reward. For organized racing and speed testing, we are not issuing the policy. Not allowed by the permit under which the vehicle is used. For this, I have give you this thing, one example. If a goods carrying vehicle, you must have seen goods carrying vehicle is carrying rods, which is the rods is completely out from the body of the vehicle. It is not within the body of the vehicle, because iron rods use the vehicle designed to carry the iron rods. It's an open body truck where this rod is being it should be the carried from the open body, where the complete rod should comes within the body of a truck, open body. So if it is carried by another vehicle and the iron rod is coming out of the body of the vehicle, then it is a case that the vehicle is not designed and not permitted by the permit. So not allowed by permit if any vehicle is being used, or sometimes goods carrying vehicle having the passenger also. COVID period, we have seen the people is being carried under the trucks also. Then the next para, the driver clause, it's a newly inserted clause as per the amendment of 2019. Driving under the influence of alcohol or drugs as laid down in section 185 of Motor Vehicle Act. We'll see what is the section 185. You should only remember the quantity of drugs under how much of the blood, that is 30 mg per 100 ml of blood. 30 mg per 100 ml of blood you need to remember. If a blood contain more than 30 mg of the alcohol within 100 ml of blood, then it is presumed that the driver or the person who was driving the vehicle not having the proper control on the vehicle, effective control on the vehicle. So that is a violation of section 185. Earlier, this section was not there in the 149(2). Now it is there. Then the non-disclosure of the material fact. This is the basic fundamental section. This is there in the. Then the non-receipt of premium. The 2 point I have highlighted, that is the driver under the influence of alcohol. That is the if a person is charged under section 185, and the another is the non-receipt of the premium as required under section 64 BB of the Insurance Act 1938. So these two should be the, you should remember, these two is the not defense for the insurance company. Where it is attractive, non-receipt of the premium. We are in the insurance industry. We see. Can anybody tell where is the non-receipt of the premium? How it is coming? Non-receipt of the premium. What is the case? non-receipt of the premium. How it is?
Check
We are-
dishonor.
Check
Check
dishonor.
dishonor.
yeah, obviously. We are issuing the policy against the checks, and check is being dishonored, being stopped, or for n number of reasons that the check is not being honored by the banks. So it's a check dishonor case. Or I, from this forum, I request all the operating office that the document should be, once you receive the check dishonor uh, notes from the bank, you should please make all the correspondence and keep the records. If in future claims comes under this motor accident third party claim comes under this policy, where the policy is cancelled because of the check dishonor, then we need to establish that we have mentioned the concerned insured, the RTO, concerned RTO, and we have documented all this. We should have the postal receipt along with the acknowledgement. These four documents along with the original checks has been returned by the bank. These five documents is sufficient to exonerate from such litigation where the check dishonor is there. So if non-receipt of premium is there, we are not liable to pay the claim compensation. So these 5 points I have mentioned. These are the specific defense that we are taking. Moving further, section 157, transfer of certificate of insurance. Important section is there. That is there. Transfer of certificate of insurance. Here, from the date of transfer of the vehicle, as per the RCS tract, certificate of insurance shall be deemed to have been transferred in favor of person to whom the motor vehicle is transferred, with effect from the date of its transfer. The date of transfer is clearly mentioned on the RCS tract of the vehicle. From the date of transfer of the vehicle, as per the RCS tract, the third party portion of the vehicle is deemed to be transferred along with the vehicle. Irrespective of the owner of the vehicle, we cannot dispute such claim that as on date of accident, we have not issued the policy to the new owner. We have issued the policy to the earlier owner, and if the vehicle is transferred as per the RTO to the proper documentation, then the third party portion is deemed to be transferred to the new one along with the vehicle. So third party portion goes always with the vehicle, that is as per section 157. Deemed transfer shall include that the transfer of right and liability. Then the section 134C, that is the duty of driver in case of accident. He should give the following information in writing to the insurer, that is the policy detail, date, time and place of accident, particulars of person injured, name of driver, and particulars of his driving license. And the expression driver includes the owner of the vehicle. As per this section 134C, we are giving notice to the owner of the vehicle and the driver of the vehicle. Anything, ma'am? Kindly mute yourself. If Vidula, ma'am, you should. Yeah. Now the section 159 is there. Information to be given regarding the accident. That is the duty of the police authority. The police officer shall prepare an accident information report to facilitate the settlement of claim within 3 months and submit the same to the claim tribunals and such other agencies. So you should remember the timeline. How much time is given for the police authority to make the entire investigation and make the information to the tribunals as well to the insurance company. That is the section 159. Then the section 160, that is the RTO, duty to furnish particulars of the vehicle involved in the accident. Sometimes the RTO is
Sir, there is
resisting
one
that
point. Sir, there is one query.
Yes, sir.
Application under section DAR system, doesn't it need
Yes, sir.
DAR, DAR
Detail
system.
accident report.
Comes under
Right.
one, yes, sir. Comes under 166 or 159.
DAR
Application.
mechanism. DAR mechanism is the that is the claim compensation under section 166 only, sir. This is the
166.
this section 159 is there, that is binding the police authority that he should submit the report within 3 months to the claim
Tribunal.
tribunal. Yeah, and to the insurance company also. We are sending the investigator to get the information from the police authority as well from the RTO, but sometimes they are denying and telling that this is the third party information, we cannot give you. So that time we are writing the letter by quoting this section, so that the Motor Vehicle Act itself telling that you should file, you should give the information to the insurance company also. RTO sometimes resisting it's a third party insurance. The remote
So
RTO
presently, whether we are settling such type of claims,
under DAR mechanism.
presently we are settling claims under DAR system also.
Sir, it was on the pilot basis implemented in the earlier in 2021. No, sir, before in 2021 in Delhi and Karnataka. So it is not full-fledged implemented till date. But
But in
nowadays,
Delhi, we are receiving the applications under DAR system.
no, sir, no directly we are receiving till date the application. Where the section 149, we discussed about the section 149, that is the DAR mechanism.
Okay. Right. Sir.
Where the timeline for the police authority only given 14 days. And nowadays, the government sector also, yesterday only I have seen one claim petition is being disposed by the national insurance company within 30 days. That was the e-filed application, and it was settled in yesterday Lok Adalat, 4 rupees 85 lakh rupees. It's a 1 crore claim. It was settled for 85 lakh by national insurance company. So nowadays, everyone is working promptly. Excuse me. Am I audible, sir?
Yes, sir.
Yeah. So DAR mechanism is there, and it will be implemented, but it was on pilot basis earlier used in Delhi and Karnataka, but rest of the country that is there. So under section 160, it's the duty of arresting authority that he should provide the information to the insurer as well to the claim tribunal by taking the prescribed fee. 159 is important, police authority. 161, claim compensation in case of hit and run motor accident. For the death case, it's a 2 lakh rupees, and for grievous hurt, it's a 50,000 rupees. Earlier, it was the too low, that the half of the NFL amount under section 140, but now it has been substantially enhanced to the rupees 2 lakh for death case, and for grievous hurt, it's a 50,000. Then the section 166 too. These two section is important, 161 and 162, because this has been enhanced and it's a new sections and new amendment is there. So question may came from here. Section 162 is telling a scheme for golden hours. Golden hours, it means the period lasting 1 hour following a traumatic injury. That the highest likelihood of preventing death by providing prompt medical care, that is the golden hour scheme. So you should remember how much hours, it's a 1 hour from the traumatic injury, that is known as the golden hour. So what is the other aspects of the golden hour scheme? The insurer shall provide the treatment of road traffic accident victim, including during the golden hour. The central government shall make the scheme for the cashless treatment of victim of the accident during this golden hour. Now come to the section 164. Earlier it was the 163 alpha. So as I have told, one new section 149 DAR mechanism just now we discussed. So this section 164 is payment of compensation in case of death or grievous hurt, where the claimant is not required to establish the fault of negligence. So it is also known as the no fault liability, where the claimant should not require to establish the fault or negligence of the owner of the vehicle or other vehicle concerned or any other person. So we will not talk about the negligence under section 164. This is normally the claim compensation under section 164 we are receiving where the negligence on the part of the rider of the vehicle.
Excuse me, sir.
Yeah, tell me.
Sir, what is the basic difference between this NFL and hit and run? I mean, when person will claim under this NFL and when person will claim under hit and run?
So hit and run is the case where the established vehicle identification is not established by the police officer. There is no CCTV footage, there is no eyewitness when the accident occurs. Most of the times or sometimes we see in the rural area, vehicle, the accident occurred and the vehicle ran away. So that is the hit and run case. And another one is the no fault liability, where the identification is vehicle there, insurance company is there, vehicle is insured, and he should not establish the negligence on the part of anyone, either the vehicle or the person who was driving the vehicle or himself also, the claimant also. So this is this section 163 alpha is inserted in the 1994 amendment, where the claim compensation for the person who is not much enough by financial, who is a poor claimant, he cannot establish the negligence. He cannot go much into the claim litigation. For that purpose, it has been inserted, and where the negligence should not be, it is not required to establish by anyone. Clear, sir?
Okay, sir. One more thing is there, sir. In NFL award, earlier we used to deduct the NFL amount from the final amount. I mean, final judgment award. But right now, the same provision is still there.
So see, NFL 2 section is there where the liability is not there. Negligence is not required to prove. One is the section 140 that has been omitted right now. So we should forget about the NFL, that is the 50,000 and 25,000. It should be deducted from the final amount. And if NFL was paid under section 140 and later on we come to know that we are not liable to pay, that also cannot be recovered from the claimant. That was the section 140. Now we are talking about the section 164 where the negligence is not required to prove. That can be termed as the no fault liability. Where also fault is not required to establish. Kindly mute my. Here also, negligence is not required to be proved. So this is the another provision that is made earlier for the claimant who may be the poor, or the where the negligence on the part of, if it is a case of child, if it is a case of 75 years old, then who was one child is running him under the vehicle. Negligence is not clearly who was negligent. So that kind of case, that kind of claim can come under the section 164. Clear, sir?
Okay, sir.
So compensation for death case is 5 lakh rupees and compensation for grievous hurt is 2.5 lakh rupees. So we should remember what is the hit and run provision, that is a 50,000 and 2 lakh rupees. For injury, it's a 50,000, 2 lakh for the death case. Under section 164, earlier 163 alpha, it is a 5 lakh and 2.5 lakh rupees. Moving ahead, 164 alpha is telling a scheme for interim relief for claimant. Why it is inserted now? Because this interim relief for compensation, now it has been omitted section 140. So now the central government may make a scheme for provision for interim relief for claimants paying for compensation. And the another section inserted is 164B. Bravo. That is the motor vehicle accident fund that can be utilized for section 161 and 162. What is the section 161? Anyone?
Hit and run.
Hit and run. Hit and run.
Hit and run.
Right, sir. Right. Thank you. So central government shall constitute a fund to be called the Motor Vehicle Accident Fund. That fund should be named as the Motor Vehicle Accident Fund. So 164B is known as the Motor Vehicle Accident Fund. So this fund is to be constituted by the central government. We have not yet received anything that the fund has been constituted, and that fund is audited by the CAG. One important question is there on this slide. Section 165. Claim tribunals. Last time also I have seen who is empowered to constitute motor accident claim tribunals. Last time this question, so many times this question has been repeated. So a state government, that this section 165 empowers the state government to constitute the motor accident claim tribunal. So please have on this, that the state government, you may have the option central government, state government, Supreme Court and High Court. So answer is the state government is empowered to constitute the motor accident claim tribunal. Section 166, this is the most popular section where the claim application is coming. Under section 164, negligence is not required to prove, but for calculating pernicity also we have seen various factors there which is required to be established for under section 166. So pernicity case is also, you can say that that case is also under section 166. So accident is to be proved, negligence is to be proved, policy should be there, the insurance policy, income is to be proved, age of the victim is to be proved, then the dependency. Sometimes the married sister is the dependent on brother. She is not dependent. So many judgment is there. So married sister is not dependent. So they will make the for reducing the personal expenses, they will make the all the entire family married sister also as a dependent. So here the dependency also required to be proved. So these six aspect is required to be proved for making a claim compensation payable under section 166. So what are the jurisdiction to file the claim compensation? Where the claimant normally resides, accident took place, where the accident took place, and where the respondent resides. These three jurisdiction is there. We as an insurance company having the offices throughout the country. So this is normally pleaded that the insurance company having the office, so claim is being filed throughout the country, whether the accident took place in that area or not, whether the claimant is resides or not. We as a respondent is residing at pan India basis. So right of claim compensation for injury, this is the important aspects. Normally proximate cause is there for making the payment, but this the new amendment telling the right of claim compensation for injury upon a death. If someone is injured, hospitalized, and then he died during the treatment. If the cause of death is not the injury only, might be he died because of the heart attack, might be he died with some other, but it is telling that his legal heirs is having the rights for the claim compensation irrespective of cause of death is related to such injury or not. Clear, sir? Report under
Please,
section 150.
sir, please explain it again, this point.
If death arising out of the injury during an accident, whether it is death occurred because of that accident or some other reason, that the legal hires is having the rights to claim compensation for accidental case. Proximate cause, normally we are talking about that the death should be arising out of that injury only. But if the death is arising out of the other reason also, then also the claim is payable. They have the right to file a claim compensation. So report under section 159 shall also be treated as application for compensation. This section 166 clearly telling what is section 159, that is the duty of someone. I have mentioned this is an important section before the
Police officer.
Duty of
police officer. Yeah. Report under section 159. Whatever the report is submitted, normally they are submitting the charge sheet by doing the investigation, so that the report will be treated as a claim application. Then section 166(3). Now this is the latest provision. No application for compensation shall be entertained unless it is made within 6 months. Earlier it was there, claim application should be made within 6 years before 1992. But later on, time limit has been discontinued and claim being filed after 12 years, 10 years also. So this provision now again inserted, and it is make the mandatory for the claimant that the claim petition should be filed within the 6 months. But there is a motor vehicle amendment bill not yet notified by the government. That bill is enhancing this timeline for 3 years, because we as an insurance company also failed to file the appeal within the specified time period of appeal time for motor accident claim tribunal. Anyone? What is the appeal time, sir? Anybody?
1 month.
90 days. Appeal time 90 days.
90 days.
To High Court.
Thank you. So if we are failed to file appeal within the period of 90 days, being a well established infrastructure throughout the country, having the good contacts, but the claimant is given only 6 months upon happening a traumatic accident with his family for filing this claim application. So that application is being delay is being condoned by the tribunal also if it is established if the claimant is prevented to filing the claim application within 3 months. Police authority is not cooperating in lodging the FIR or something else, maybe there's some other reason. So this is important. 166(3). Section is not coming. We will ask what is the timeline for filing claim compensation, what is the time limit given for the insurance company for satisfying the award, what is the time limit for the insurance, this the police authority for making the accident report, and all this kind of question is coming. Section is not important. Some section is important which may be asked that I will discuss that the section 165 that empowers the state government, and the earlier section, the 147, where the defense 152, these are the sections. Section may be asked. Section 167, this is a section you should not remember, but what is inside the section you should remember. Option regarding claim for compensation in certain cases. Earlier, driver was not treated as a third party. He can only file the claim application under WC forum. But driver of the vehicle can file the claim application for the another vehicle against the another vehicle which involved in the accident as a third party For the other vehicle, he will be he is treated as a third party, and he can file the claim compensation under MACT forum also against the another vehicle. So he can file the claim compensation against the another vehicle in MACT forum or in WC forum against his own vehicle, but not uh, under both the forum, both the act. So this section 167 of the Motor Vehicle Act is barring an individual to either file the claim compensation under this section of the Motor Vehicle Act or the EC Act, WC Act. That is a section 167. Section
Sir,
166.
earlier also this section is there, sir.
Earlier also this section was there. Earlier also this section was there. Section 168, award of the claim tribunal. Here the timeline is given. Award should be given by the claim tribunal within 15 days, and that should be satisfied the insurance company within 30 days. Section 170 is there. (170) is very much important. You should not remember the section number. Here the section number may be asked from the exam point of view. In pleading insurer in certain cases, this section is very much important for filing appeal, whether we have filed the application under section 170 or not. What is the section 170? Right to contest the claim on all or any of the ground contained in the section 152. Earlier it was the 149(2). That's the difference for the insurance company. Now it is a 152. So this is the right of an insurance company to contest the claim. What is the condition? In what case the insurance company is allowed to file the claim application under section 170? That there might be a collision between the applicant and the insured. There might be a case that the person have accident because of some other reason, maybe fall from the tree or maybe fall from the roof of somewhere else, and they are claiming that he met with an accident. So there might be a collision between the owner of the vehicle and the claimant. So in that case, insurance company is contesting the claim petition on the grounds whatever mentioned in the section 152. Then the insured, so many times insured has failed to contest the claim petition. We as an insurance company directly contesting the claim, where the insured is a third party, where the section claim application under section 170 is being applied. So this section is very much important. So in such case, tribunal may direct the insurer who may be liable in respect of such claim shall be implicated as a third party, as a party to the proceeding of the third party. Section 173. This is the important section. Section might be asked from the exam point of view directly, under which section we are filing the appeal. So that is the section any person aggrieved by an award of a claim tribunal may, within 90 days from the date of the award, prefer an appeal to the High Court. So this is the section 173 by which we are filing the appeal to the High Court or to the higher court. So what is the statutory deposit which is required to be deposited before the High Court? That is the 25,000 or 50% of the award amount, whichever is less. No appeal for the less than 1 lakh rupees of dispute amount is preferred before the High Court. Earlier it was a 10,000 only. So if the disputed amount is less than 1 lakh rupees, appeal will not sustain as per the new amendment act. And what is the statutory deposit need to be deposited? Either the 25,000 or 50% of the awarded amount, not the disputed amount. There is a difference between the awarded amount and disputed amount. We can tell that the The tribunal should consider the 10,000 only monthly income, and tribunal has considered the 12,000 monthly income. So claim compensation is total claim compensation, suppose 4,50,000 awarded by the tribunal, and as per our calculation, if it is a 4 lakh only, so there is a difference of 50,000 only. So that case cannot be sustained before the High Court. High Court may entertain the appeal after the expiry of these 90 days if it is satisfied the appellant was prevented by sufficient cause from preferring the appeal in time. Suppose date of award is the 1st 2023. Tribunal should give the certified copy of award within 15 days. But we have applied the very next day of the award. Advocate has applied the very next day of the award. But they have prepared the certified copy of award after the 90 days. That means we as an insurer prevented for filing the appeal. We as an appellant prevented by the sufficient cause by filing appeal. So such cases, such delay can be controlled by the High Court. So what are the requirements? Section 170 application is mandatory to file appeal except orphan claim. I have mentioned orphan claim where the policy is check dishonored, policy is cancelled because of the check dishonor, false policy, or not insured. In such cases, 170 application is not required because these cases itself is telling the owner of the vehicle is not insured. He is not insured. If the check is dishonored, he is not the insured on our record. Another point is there, ground of appeal should be pleaded before the lower court. So you should remember the section and you should remember the statutory deposit amount and the another amount which is disputed amount sustainable before the court. What the other facts I have mentioned in the slide and explained. Driving license. Moving ahead for the driving license. This is as per the latest amendment. Earlier it was the other timeline. I have simplified the driving license. Driving license should be effective and it should be the qualified also. Effectiveness is not only the documentary validity of the license, also authorized for the class of the vehicle. So motorcycle with gear, adapted vehicle, we'll see the definition of adapted vehicle. LMB with gross vehicle weight up to 7,500 kg. So these are the types of the license which is being issued, and for that the effectiveness and qualification is there. What is the effectiveness? If it is a age up to the 30 years of the age, the license is being issued till the age of the 40 years. If the age is ranging from 30 years to 50 years, the license is issued for 10 years. If the age is ranging from 50 years to 55 years, that will till 60 years of the age. And if the age is above 55 years, it's for 5 years. License is being used. Minimum age for this class of the license, 18 years, no other qualification is required. Any clarification in this needed, please ask.
1 second, sir. Above 60, you will not issue any driving license? Hello?
Yeah, understood, sir. If the age of the person having the age more than 55 years, I have not mentioned the further age. Driving license may be issued for a person who is having the above the age of 60 years, but it should satisfy the whatever requirement of the transport authority, regional transport RTO. That is, he should be medically fit, the eyesight should be clearly. These are the other criteria. If a person having the age of more than 55 years, he will issue the license.
Not audible.
Am I audible now, sir?
Yes, sir.
Yes, sir. If you switch off your video, then the voice is clear.
It will be more. Yeah, now for transport vehicle, earlier it was for 3 years, and now it is 5 years. Minimum is 20 years, and the qualification is 1 year after the issuance of light motor vehicle license, LMB license. So if someone is having the transport license, it is understood it must have the LMB license for 1 year, and he can drive the class of vehicle having the LMB less than 7,500 kg of the weight. And the roller, it is for 3 years. Medical is required to drive the road roller. Minimum is 20 years. Then the endorsement to carry hazardous goods, 3 years. Earlier it was the 1 year. 3 years, and renewal thereof as per the condition of the central government that may be prescribed. What are the requirements? Requirement is the medical, transport license, English, and one of the language from the Schedule 7. You should remember the Schedule 7. You should know the two languages. One language is English, and the another language is that is mentioned. One language from the Schedule 7. So the driver should know the two language. He should medically fit and having the transport license, then the endorsement of the hazardous goods. Moving to the next slide. Anything in the license you need to ask? Moving forward.
Sir, after
Expired
expiry of
license.
3 years, again he needs to go for the test, sir, for hazardous goods. After 3 years expiry, what he has to do, sir?
Refresal course is being carried out by the authorized agency, that is authorized by the state government. That is the one-day training that need to be conducted for renewing the hazardous goods endorsement.
Okay, sir.
Expired license, if the application for renewal of the license is made either 1 year prior to date of its expiry or within 1 year after the date of expiry, renewal of license will be done with effect from date of its current expiry, current renewal. Is it clear? Earlier it was the 30 days. We are treating the license valid till 30 days after the expiry of the license. Now this has came for the expiry of license for 1 year. So before 1 year also one can one can apply for the renewal, and within the 1 year, within the timeline of the 1 year also he can apply for the renewal. Renewal will be with effect from the date of the current expiry, that is the date of the renewal. If the validity of license has lapsed for more than 1 year, then only driver shall have to undergo refresher course. Application for all type of license except learner license. This provision is applicable for all kind of the license. Medium goods vehicle, medium passenger vehicle, and heavy goods vehicle, heavy passenger vehicle have been replaced by a single entity, that is a transport vehicle. And you see on the RTO extract, it is in the column class of vehicle COV, it is written as a trans. That means he is authorized to drive 4 kinds of vehicle, that is the medium goods and passenger vehicle and heavy goods and passenger vehicle. This amendment has came in 1994 only, and it is in effect from 14/11/1994. LMB non-transport can drive LMB transport vehicle that was notified by the Ministry of Road Transport and Highway dated 16 April 2018 in compliance with the judgment, that is the Mukund Devgan versus Oriental Insurance. Section 25 alpha, this is the newly inserted section. Question may arise from here. National Register of DL. You see, nowadays the license is mentioning the state, the initial is the mentioned as the UPMS like that. But now this provision is telling the National Register of DL, the central government shall maintain a National Register of DL. All the state register of DL shall be some under the caption register by the date of notified by the government. So this is yet to be notified and required to be made. Moving ahead, this is all about the license. Now the definition, you might be aware about all these definitions. So quickly we'll move ahead. Adapted vehicle, also earlier it was known as the invalid carriage. Motor vehicle, especially designed or constructed for the use of a person suffering from physical disability. Then the articulated vehicle, a motor vehicle to which a semi-trailer is attached. Then the maxi cab, sitting capacity more than 6 up to 12 excluding driver. Motor cab, sitting capacity not more than 6. Then the motor car, a motor car is a vehicle other than the transport vehicle. Transport vehicle I have mentioned. Then the light motor vehicle, as per definition, a transport vehicle or omnibus whose gross vehicle weight and motor car, tractor and road roller whose unladen weight is less than 7,500 kg is known as a light motor vehicle. I have simplified very much what is the definition for light motor vehicle. For transport vehicle only gross and omnibus gross vehicle weight is being looked, and for motor car, tractor and road roller you need to see the unladen weight. It should be the less than 7,500 kg. That is a light motor vehicle weight. What is the gross vehicle weight, unladen weight, and the capacity of the transport?
The seating capacity of omnibus is
Sitting capacity of omnibus is not mentioned as a sitting capacity. You might see the omnibus 30, 40. They have the 22, I think 47, 20 to 27. Maxi cab, motor cab, and motor car. Two is there. Maxi cab and motor car is there. Omnibus, nothing is mentioned about the omnibus. You see the gross vehicle weight of the omnibus, not as per the city budget. See, for checking the driving license, only we have the two criteria. Either it is a light motor vehicle or it's a transport vehicle. Because the transport vehicle is covering all these four kinds of the vehicle. Absolute liability, where the insurer is liable to compensate and has no defense under section 152. The defense, what we have discussed already. Breach of policy terms and condition. If it is there is no breach, then we are absolutely liable to pay the compensation. Then the composite.
Sir, in the JVW there was a unleaded weight and capacity. What is capacity?
Capacity, if it's a goods carrying vehicle, it's a weight of the vehicle, weight of the goods which is being carried, and if it is a passenger vehicle, it is a sitting capacity. Sitting capacity multiplied by it's a normally average unladen weight with capacity.
In the goods carrying there was a GVW, and the passenger carrying there was a sitting capacity.
Yeah, right, sir. That is the capacity.
Okay.
Composite negligence, where the negligence on the part of two or more person or the vehicle. Absolute liability up to the negligence percent of the insurance paper. That you need not to emphasize more what is the absolute. In the case of composite negligence, we are absolutely liable to pay the compensation till the percentage of negligence of our vehicle. Then the contributory negligence, that is the negligence on the part of injured itself, whether he has contributed to the accident or not.
there is a definition, slightly variation with contributory and composite. In contributory negligence, the injured itself contributed to the negligence. In composite negligence, negligence on the part of more than two vehicle owners. Clearly, composite negligence, claimant may or may not be negligent for the injured may or may not be injured is not there in the composite negligence. There is a negligence on the two vehicle, two person, two driver of the vehicle. Clearly, vicarious liability, master holds for the servant negligence. As per this vicarious liability, only the owner of the vehicle is holds for the negligence of the driver. Tortfeasor, person who is responsible for negligence. These are the words definition which is coming in the exam. Res liquidator, this is the important thing that speaks for itself. One important aspects, educational institution bus, school bus is not same as the commercial. There is a judgment, Mehta versus Union of India. Some other important section of the Jadhav sir, excuse me, Anil Jadhav sir is there in the meeting. Sir, should I take 10 minutes more lecture if all the participant is comfortable?
Yes, sir. Yes, sir. Please continue.
Yes, sir, please.
I'll update Anil, sir.
Thank you. Important section of the Motor Vehicle Act and IPC. Section 3 is telling about the necessity of license. We should remember the basic document and the DL of the motor vehicle, which is important for claim making the claim payable. That is a license, RC, permit, fitness if it is a goods vehicle. So you should remember what are the section where it is mentioned for these all the four documents. So section 3 is the necessity of the driving license. Section 4 is prescribing the age limit for holding DL, which we have discussed in the DL column. Section 181 is the important section where the DL is not valid and the person is not having the DL driving the vehicle in contravention of the section 3 or 4, then the section 181 is attractive. And we are seeing on the face of the charge sheet that the 3/181. It means he was not holding the valid DL at the time of accident or at all not holding the DL. That is the contravention of section 3. Or the under person is the driving the vehicle, that is the section 4. Imprisoned for 3 months or a fine up to 5,000 rupees or with both if a person is punished under section 181. Section 8, grant of learning license. Learning license validity is up to the 6 months and he can apply for DL after 1 month. Section 9 is granting the DL. So section 8, you should not remember. You should remember section 181, section 3, 4, most important. 25 alpha, we have discussed National Register of Driving License. We have already discussed the section 25 alpha that yet to be constituted by the central government. Section 39 is the necessity of registration before bringing the vehicle to any public place. So many times accident occur before registration of the vehicle. We have issued the policy for satisfying the RTO formality for making the vehicle for registration and it met with the accident. In that case, if the vehicle is not registered, that is a violation of section 39. We are not payable. Section 43 is the temporary registration. Validity is only 1 month. OD part also may have covered this temporary registration. Section 56, certificate of fitness. You should remember section 56 and 66. One is for fitness, another is for the permit. Section 56 is the certificate of fitness for transport vehicle, not deemed to have valid registration if not having a fitness certificate. Normally, validity RC is renewed up to the validity of the fitness. If the fitness is the roadworthiness of the vehicle, whether the vehicle is still fit for playing on the road or not. So this section 56 is specifying the necessity of the permit. Then the section 66, necessity of permit. No owner of a motor vehicle shall use or permit the use of vehicle as a transport vehicle in any public place unless authorized by the RTO. It is applicable for transport vehicle. Fitness is applicable for both the vehicles, private vehicle also, and transport vehicle also. But fitness for private vehicle is being issued for 15 years. That's why we are not seeing whether fitness is valid for private vehicle or not. But after 15 years, that vehicle should be satisfy the requirement of the RTO, whether it is fit for playing on the road or not. Above provisions shall not apply to. These are the vehicle kinds of the uh, authority who is using the vehicle where the provision of permit is not applied. Quickly we will go. Vehicle owned by central or state government, owned by local authority, municipal corporation, used solely for road cleansing, watering, conservancy, used solely for police, fire brigade, ambulance, used solely for conveyance of purposes, used for towing or disabled vehicle, removing goods from it. Sir must have discussed about the towing of the vehicle. Any goods vehicle whose gross vehicle weight does not exceed the 3000 kg. Two GVW is there, one is 7500. Below 7500 is the light motor vehicle, and another vehicle whose GVW does not exceed 3000 kg, permit is not. Whether it is a transport vehicle also, permit is not. Any transport vehicle going for registration, before registration permit is not being issued, and it is also not applicable. Any transport vehicle diverted due to the natural calamities to reach the destination. Permit is issued at the pan-India basis known as national permit, and the other local permit is also being used if there is a natural calamity and vehicle is diverted to reach the destination permit. Section 129, wearing of protecting headgear. It is applicable for two-wheeler. Sikh, if he is wearing the turban, he is not. He can. This protective headgear is not required. So there is a section 129 which is clearly mentioning about the wearing of headgear. Then below the 4 years of age, what is required? Above the 4 years of age, everyone is required to wear the helmet. Safety harness attached with the rider, that is required for below the age of 4 years. If a child is there, that the safety harness is required to be wear. Then the section 134. 134C we have seen duty of the driver, and 134 is duty of the driver in case of accident. We have discussed this section. What are the duty? He should take the injured person to the nearest police, will inform the incident to the nearest police station. Within 24 hours, will inform the insurer about the accident. What is the timeline? You should remember the timeline. Within 24 hours, you should inform the police authority. 134 alpha, a good Samaritan. Important section is there. We have discussed about this good Samaritan. Shall not be liable for any civil or criminal action for any injury, death of the victim of a motor vehicle accident which has resulted during rendering the emergency medical or non-medical care or assistance to the victim. What is the Samaritan? A person who is in good faith, voluntarily and without acceptation of any reward or compensation rendered emergency medical or non-medical care or assistance at the scene of an accident to the victim or transport such victim to the hospital. So this is also related with the golden hour. There is a scheme that the Good Samaritan will awarded with the compensation of rupees 5,000 per injured person. If someone is helping or two more person is helping a single person, both will get a compensation of 5,000 rupees combined, not individual. That notification has been already. Then the section 185, driving by drunken person or by under the influence of drug. Important section is there. You should remember the what is the content of alcohol. That is a 30 milligram per 100 ml of blood. If it is deducted, it is treated that the person is incapable of exercising proper control over the vehicle. Then what are the punishment? For first offenses, it is a 6 month or up to the 10,000 rupees of fine or both. For second offenses, 2 years or 15,000 or both. Then the section 187. If section owner of the vehicle is not cooperating with the police authority, this section is attractive. Some important section of the IPC is also there. 279 is there for rash driving. Normally this section we are seeing in the police paper. 337 is the causing hurt by endangering life. 338 is causing grievous hurt. 337, 338 is normally in the case of injury, it is being there. 330 is more important if someone is claiming for the claim compensation under section 164, that is for rupees 2,50,000. If 330 is there, it is a grievous. 304 alpha I have discussed, it's a causing death by negligence. 304 alpha is important. Then 302 is punishment of murder or causing death intentionally. These two sections I have mentioned. Normally motor accident, there is a charge which is driver charge seated under section 304 alpha, not under section 302, because if case is of 302, we are not liable to pay because there is an intentional death or murder. 427 you have seen so many times, it's a massive causing damage to the amount of rupees 50. So these are the important section of IPC. Then come to the Consumer Protection Act 2019, that is with effect from July 21. Consumer can file the complaint within 2 years. However, provision is there for the condonation of claim. What is the jurisdiction? Same jurisdiction where the claimant, where the opposite, or at the place of the transaction. Where the under section 166, it was the place of accident. Here the place of transaction, where the this is happening. District Commission amount in dispute up to 50 lakh. Clearly, I have mentioned. Latest it is there. That is, if a amount in dispute is up to 50 lakh, district forum, financial jurisdiction of district forum is there. Appeal can be filed within 45 days from the date of order, and appellate authority is the state commission. 50% of the award amount is to be deposited before filing an appeal. This 50% is also there in the under section 166, but there is a minimum amount also there, that is the statutory deposit of 25,000. Then the state commission, more than 50 lakh but less than 2 crore rupees. Consisting of one president and 4 members, other provision is there. Appeal from the state commission to the national commission, that is a 30 days, and appeal from the national commission to Supreme Court, apex court, is also the 30 days. Here also 50% of the awarded amount is to be deposited for filing appeal. National Commission will look after only the cases which is having the more than 2 crore rupees. Option for second appeal and mediation has been given the statutory status. Second appeal is also there. That can be done. Then come to the any question from the consumer forum.
because I have quickly summarized the consumer. We should move ahead. Now the come to the
Hello.
yeah. Tell me, sir.
Regarding transaction,
Yeah,
what is that meaning?
where the transaction is happening. If we have purchased something from somewhere in the city of Thane or in the city of Mumbai, that the place is there where we can file the
With regard to
consumer.
commissioning, with regard to commissioning,
With regard to
place.
place of transition,
Yes,
see
sir.
if it is a Mumbai area, Mumbai district is having the district consumer forum.
Maybe the office of the insured,
Insured, yeah. For our case, it's a insured office.
office of the insured,
Yeah,
transactions.
policy issuing office. Yeah, you can. Then come to the ombudsman appointment.
Time period for appeal in National Commission.
30 days, sir.
30 days.
See, one correction is there. Earlier, last year also, this year exercise also, this question is repeatedly being asked in so many forums. But there is a, I have replied 10 times also in the group also somewhere also. Before the state forum, it is 45 days. Before the national forum, it is a 30 days. That you have to remember, 45 days and 30 days. There is a notification that presently I cannot show you, but in the group I will post that the consumer act, the amended act itself, it is a telling that is a 45 days. If it is a dispute from the district forum to a state forum, it is a 45 days and the 30 days. You should remember in the descending order. Initial one is the 45 days, another one is the 30 days. For the financial jurisdiction, you should remember the ascending order up to the 50 crore and up to the 2 crore and above the 2 crore. There are also a confusion as per the Consumer Protection Act, that is the 19, which was in effect from 21. That was telling about the 2 crore and 10 crore, but that was reduced by the latest notification, government or notification has came, which restored the earlier financial jurisdiction of 50 lakh and 2 crore. That you should remember, the two figures only. 50 lakh and 2 crore, not the 2 crore and 10 lakh, 10 crore. Clearly about the consumer forum. Moving to the ombudsman. For 3 years or up to the age of 65 years, this is the ombudsman appointed, the age criteria for the ombudsman. The area of complaint, what are the area? Any partial or total repudiation of claim if it is there, dispute with regards to premium paid or payable, dispute on legal construction of the policy wording, and delay in settlement. These are the area where the ombudsman can non-issuance of policy after the receipt of the premium. Normally, it is not being seen. Matters can be referred for an amount in dispute not exceeding 30 lakh. That here you need to remember 30 lakh. There consumer 50 lakh and 2 crore. Here you have to remember if the amount in dispute is less than 30 lakh, the ombudsman can take such matter. What are the conditions? Should have filed complaint against the insurer and not received the satisfactory reply. Note made later 1 year of the reply of insurer. From the day of reply of the insurer, he should go to the ombudsman, file application within 1 year. Same complaint should not be pending at any court of law. If there is a consumer case or some other court of law is there, then they cannot reach to the ombudsman. After deciding the case, ombudsman shall make aware the insurer as well the complaint about his recommendation within 1 month. Complainant has to reply within 15 days. These two provisions.
This is not available for the
Not available for the
corporates.
Sorry, sir. Sir, your voice is not clear.
This is not available for the corporates. It is only for individuals, na?
Yeah, I have mentioned here again. An individual only can lodge complaint. That is mentioned. Within 3 months
Okay,
from the date of receipt of complaint, ombudsman shall pass an award. What are the insurer cannot challenge this award? Complaint can challenge before the consumer forum. What is the duty? To inform the policyholder regarding the ombudsman in whose jurisdiction his office falls. Insurer, that is the duty of insurer. Claim lodged by corporate client does not come under the purview of ombudsman. That is our. Then this, see some notification I have mentioned. This is the MBA Amendment Act that I have mentioned, the 9 August 2019. This is the Amendment Act 19 claims. Then this is the National versus Pernicity, that is the 31st October 2017. This pernicity is most important. Then this Ministry of Road Transport by 22nd May 18. This is not applicable right now, so we will not discuss much in this. This is for 163 alpha. Now it has been revised for 164. But if question came that you should remember the 25,000 for the minor injury. This is the amendment in the 163 alpha in 2018. One is the 5 lakh rupees, another is the 5 lakh plus the percentage of the disability. 5 lakh and 5 lakh and the percentage of the disability for the injury case. Will not go much deep into because this is not relevant right now. 164 has came for 5 lakh and another amount is what for the injury? Anyone? 164 alpha claim.
2.5 lakh.
2.5 lakh. Then this is the 3rd January 20 where the wages under the WC forum has been increased to 15,000 rupees monthly wage. Then this 5th April 22 notification. This is about the transport vehicle. If the age of the vehicle up to the age of 8 years, it may be issued with a fitness certificate for 2 years. So initial 4 certificate will be issued for the 2 years fitness certificate. So while seeing the awards, while seeing the claim application, we should remember that the fitness certificate now being issued for the 2 years if the age of the vehicle is below 80 years of age. Then 15 February 23. This is about the safety harness of the child. Any questions, sir? Within last 10 minutes, we will conclude.
Sir, please show the last slide.
Sir, this is the 5522 circular where safety harness for children below the age of 4 years is mentioned. I have highlighted this first paragraph. For children below 4 years, safety harness shall be used for attaching the child to the driver of the motorcycle.
Yes, sir. Thank you, sir.
Should we conclude this? So thanks for listening me and thank you
Thank you very
for
much.
your
Thank you,
attention
sir.
and
Thank
all
you,
the
sir.
all the
Thank
very
you,
best
sir.
for having the exam.
Yes, sir. Thank you, sir.
Thank you, sir. Thank you.
Thank you, sir.
Thank you very much, sir, for such a wonderful session. It was very informative, and as everybody can understand that this third party is very important from examination point of view as well as our personal life also. Whatever points you have mentioned today, that can be used for our general awareness also, sir. So once again, I thank you on behalf of Mumbai Insurance Institute. Thank you so much, sir.
Thank you, sir.
Okay.
Okay. I'll leave it.
Yeah. Yeah. Thank you.